You hear me? Hi, everybody. I'm going to ask you to all take your seats and get settled so we can get started. Thanks. My name is Judy Applebaum. I'm Director of Programs at the American Constitution Society. And on behalf of ACS and the Center for American Progress, I want to welcome you all. I want to thank our distinguished panelists for coming today to talk about this important topic. And I want to thank the Center for American Progress for hosting us today. A quick word about ACS for any of you who aren't familiar with us. ACS is a national organization of lawyers, law students, scholars, policymakers, and others working to advance a progressive vision of the Constitution, law, and public policy. And as part of that mission, we organize a variety of events, including briefings about important Supreme Court cases like this briefing. In fact, we're hosting another event, another ACS event, on these same desegregation cases in the same location on December 4th, the evening of the day the argument will be heard in the Supreme Court, featuring advocates before the court and other experts to digest the argument and review the day's events. Flyers on the details with the details of that event are available up front on the table. If you'd like to learn more about ACS, to join us, get information about future events, you can go to our website, which is www.acslaw.org, excuse me, acslaw.org, and sign up, and you don't have to be a lawyer to do so. So before turning this over to our moderator, I've been asked to ask everyone to please turn off cell phones and pagers and anything else that makes noise because of the filming. And also to hold your questions till the end. We've asked our panelists to be sure to leave plenty of time for Q&A from all of you. With that, I'm going to introduce our moderator today. Our moderator is Phil Tegler, who is the Executive Director of the Poverty and Race Research Action Council. Phil is a civil rights lawyer with many years of experience, including in the area we're here to hear about today. When he was with the Connecticut ACLU, for example, he litigated Sheff versus O'Neill, a school desegregation case, and he's been involved in many other cases in this area, in the area of race and poverty as well. So, Phil, why don't you take it from here? Thank you.
Thank you, Judy. I'm going to provide a brief overview of the Louisville and Seattle cases so we're all on the same page here. And then I'm going to introduce this amazing panel that ACS has brought together. The immediate issue in these cases is whether it is constitutional to use race as a factor in student assignment in elementary and secondary education. In this sense, the cases are the next logical step for the court after the Gratz and Grutter University of Michigan cases in 2003 involving race-conscious selection factors in college and graduate school admissions. In those cases, as you all recall, I hope, the court held that diversity was an acceptable justification for race-conscious programs in higher ed, and that they could be used as long as they were carefully designed and not operating as a mere quota system. The cases being argued this coming Monday are moving the court beyond the original context where the so-called reverse discrimination or affirmative action cases originally developed, where a job or a valuable government contract or a seat in an elite college or graduate school is at issue. In the cases being argued Monday, the only government benefit being fought over is a seat in a regular public school, which on its face is like any other public school. And the reason plaintiffs object is simply because race is being considered as part of the decision-making process. Many have argued that the extension of the affirmative action analysis to this new context is inappropriate and calls into question the use of race in a whole range of other public programs that have nothing to do with affirmative action. Why did the Seattle and Louisville school districts adopt race as one of the factors to be considered in assigning students? In the case of Louisville, a long-standing federal desegregation order for the whole metropolitan county, based on a finding of de jure segregation, was dissolved in the year 2000. The Jefferson County District knew that if it did not take affirmative steps to maintain integration, the district would quickly resegregate. In the case of Seattle, there was never a court finding of unlawful segregation, but the city had a significant history of de facto segregation and had run a cross-town busing program for a number of years. When that program was discontinued, the district decided that using race as one factor among many in student assignment would keep the schools roughly balanced near the citywide levels of student enrollment, which were roughly 60% minority and 40% white. In both of these cases, the school districts believe that racial integration carries with it strong educational benefits, which are not limited to student achievement on standardized tests. And in both cases, as we pointed out in the amicus brief that we submitted, the segregated housing patterns underlying the school zones, which the segregated housing patterns themselves were largely the product of government action, would foreseeably lead to school segregation if the school districts did nothing, if they did not take affirmative steps to integrate. Very briefly, how does Seattle and Louisville use race in their student assignment policies? And I'll give just the briefest of thumbnail descriptions of this. You can read more about this in detail on the Legal Defense Fund, NAACP Legal Defense Fund website, or perhaps some of our speakers will get to it. Seattle had a system that used race as a tiebreaker for high school assignment in a citywide open choice system after consideration of several other factors, including parental choice, sibling preferences, and geographic location. The purpose of the tiebreaker was to try and maintain some level of integration in the high schools in the predominantly white areas of the city of Seattle. Louisville has a more complex system that combines magnet schools, parental choice, drawing of district lines, and finally, if all else fails, consideration of race as a factor in student assignment. The Jefferson County District, which includes both the city and suburbs, has a 34% black enrollment. And the goal of the plan is to maintain a range of student integration between 15 and 50% in every school in the district. And in both districts, the vast majority of students get their first choice schools prior to the use of any racial tiebreakers. Finally, the legal analysis that the court will follow in these cases will first be to determine what level of constitutional review will be applied to the case. Since race, which is a protected class under the 14th Amendment, is at issue here, the court is expected to use a strict scrutiny standard of review. Some, including the NAACP Legal Defense Fund, have made a compelling argument that strict scrutiny should not apply here, but I think most observers expect that it will be used. Once strict scrutiny analysis is applied, the question then becomes, is there a compelling government interest in the program? And if so, is the program narrowly tailored to achieve that goal? Now, most of the arguments in the case, and in the amicus briefs filed on both sides in this case, focus on whether there is a compelling interest in diversity or integration in K through 12 education, and what is the social science basis for that compelling interest. As important as this question is, many of us expect that the court will accept the importance of integration as a goal, and that the outcome of these cases will turn on the question of how the programs are designed, the so-called narrowly tailoring prong of the test. Are the race-conscious elements of these plans necessary to achieve the integration results? Do these programs constitute a mere quota, or do they balance a number of factors? Has the program been designed to minimize unfair consequences to third parties? These are the kinds of questions the court may be looking at in the legal context in which the arguments will play out. I'll now turn the discussion over to our panel. I'll give some brief intros. You can look in your packets for the full bios for each of these folks. We'll start off with John Payton on my right. John and Francisco Negron are both at the edge of the table, so they're at risk of falling off the stage at some point this afternoon. So keep an eye on that. That'll add a certain tension to the whole event.
And is the lesson that we should be cautious in moving either to the left or the right?
Yes, that's right. Stay right there in the center. John Payton was lead counsel for the University of Michigan in the Gratz and Grutter cases in 2003. He argued Gratz in the Supreme Court, and he's recognized as one of the leading experts, obviously, in this field of law. We're very lucky to have him here today. In the Louisville and Seattle cases, he is counsel of record in the amicus briefs filed for the American Psychological Association. He has a long background in these issues, including his representation of the city of Richmond in the Supreme Court in the important minority set-aside case of Richmond v. Croson in the late 1980s. And I'll hold off on the other speaker intros before each of them go. We'll start off with John.
Thanks a lot, Phil. Can everybody hear me? Is this mic operating? Is that good? I think the first question is sort of why are we looking at otherwise a K-12 school district that is trying to decide on school assignments by reference to the Grutter case about law schools. Another way of looking at this would be to say the desegregation cases, and there's a long body of desegregation cases. Louisville was a desegregation case all through the lower courts and cert denied. The desegregation cases ought to be the way you look at this. And Seattle was also a case that raised the body of law that is the desegregation cases 10 years ago, when it voluntarily took action to deal with what it thought were segregation forces in its school district. But the reason we're not using that body of law, or the reason we're sort of in between bodies of law, is because Louisville has been declared a unitary system no longer under court order, and therefore it cannot say that it has a compelling interest of remedying past discrimination. Seattle makes no claim that it is attempting to remedy discrimination. And therefore the question is there another compelling interest that could allow them to use race for the purposes they've been using it? And the obvious example is what happened in the Michigan cases in Grutter. And so the first question that comes up is, what is the relationship between a K-12 system and what the court decided in the Grutter case? And I think there are two main points. The first one Phil made. In a law school, highly selective, with all sorts of criteria that you have to establish to even be competitive, very small percentage of the students who apply actually end up going to the law school. Some of the students who apply get rejected and end up going to other law schools that they didn't want as their first choices. Some don't even go to law school. So there are consequences. That is, some students don't get to do what they wanted to do. In the fifth grade, in a public school system, where the record in this case says the schools are all functionally the same, the fifth grade's the fifth grade. There are no qualifications. You just had to get out of the fourth grade, okay? And if you got out of the fourth grade, you get to go into the fifth grade, and if they're all the same, it's just the fifth grade. And in that sense, it's very misleading to say this is a case about affirmative action, because the obligation of every public school district is every kid that shows up, we're going to find you a place in the fifth grade. And it'll be functionally the same place in the fifth grade. So in that respect, this is very different lay of the land than University of Michigan Law School. The second issue that comes up is what's the difference or the same about the salience of race. In the law school case, the Supreme Court clearly held that the education that comes from a diverse student body is really important, sufficiently important to be entitled to be a compelling interest for the purposes of constitutional analysis. This is Justice O'Connor from the Grutter case. Some of you have heard this line before. This is Justice O'Connor. Nothing less than the nation's future depends upon leaders trained through wide exposure to the ideas and mores of students as diverse as this nation of many peoples. Okay, so really, one sentence, I think, tells you the whole story. Diversity has enormous value to the entire country and to all of the students. And it's sufficiently important that it's a compelling interest for constitutional analysis. Now, the second issue that we have to address is, does diversity have the same importance in K-12 as it does in law school. And I think that the evidence that's been presented in both of these cases, in the cases themselves and in an enormous array of amicus briefs, actually says that diversity is even more important when you're talking about the fifth grader than you're talking about the law school student. And the reason, I think, is absolutely intuitive. The challenge for someone who is 22 is to figure out what you can get out of a diverse classroom that causes them to have a different sense of themselves and, in many instances, to abandon, after seeing the stereotypes that they carry around from their life of baggage in our society. For the fifth grader, actually, they don't have that baggage, and the task isn't to make people walk away from their stereotypes. In fifth grade, you can actually prevent kids from even developing the stereotypes. So the value of diversity as an educational matter for the fifth grader has many, many more significant possibilities than for the 22-year-old. And I'd say the social science evidence for that is very, very substantial and growing. That we have a lot of studies that are out there, and to the extent there are any quibbles about it, the quibbles are about the way in which you try to take advantage of the diversity. I don't think there's any real argument that when done the right way, the diversity has enormous benefits for the kids, in the sense that they come out seeing all of their classmates as their peers, not as other people who do things different from what they do. It has an enormous benefit for our whole society. Now, the challenge for a school district is that the diversity that is necessary for those benefits to come about doesn't just happen by itself. Parents, for the most part, make choices for students who are in K-12, and the parents in most of our urban areas have made choices that result in most people living in racially and ethnically homogeneous neighborhoods. And if you leave it to the parents, they make similar choices about their schools. They are risk averse. They make decisions that are influenced by their own backgrounds. And for that reason, school districts like Louisville and Seattle have concluded that they need to use race in some modest way in order to achieve the diversity in the schools that will yield the benefits that I just described. I think the last point has to be sort of restated. All of us know that what I'm about to say is true, but we act in our daily lives like it's not. We're a very separated society. People live in neighborhoods that have one racial or ethnic dimension, and the exceptions are quite limited, and you know those well. You know where you live, you know where your parents live, you know where your friends live, you know what those schools look like. Most large urban areas are minority inner cities surrounded by white suburbs with occasional black suburbs, sometimes even a Hispanic suburb, and the schools look like that as well. And school districts are trying to figure out how, given that lay of the land, they can generate the education for all of their students that brings us together as a country and as a society.
Thank you, John. Our next speaker is Francisco Negron. Francisco is Associate Executive Director and General Counsel with the National School Boards Association and helped prepare the NSBA's amicus brief in the Louisville and Seattle cases, which focuses on the value of local control of education. Before coming to the NSBA, Francisco served as General Counsel to the Escambia County School Board in Pensacola, Florida, a school district of about 45,000 students, and he also served as staff counsel to the Florida Education Association United, an affiliate of the AFT. So, Francisco.
Thank you. I think that for school districts, the primary concern, other than this local control issue, is the question of diversity as a legitimate educational or pedagogical concern. I mean, teachers know, administrators know, and school board members know instinctively, or maybe really professionally, what Americans know instinctively, and that's that diversity is an important American value. So in recognition of that, school boards are trying to deal and cope with what is really a post-integration society, right, where we have voluntary patterns of migration, we have certainly segregated housing patterns in certain places. And what school districts are doing is engaging their local communities to develop policies that make sense for them. It's curious that in sort of the Brown cases, school boards were almost with their cheek in their tongue arguing about local control to achieve a rather nefarious purpose, and I'm glad that that's not where we are here. We're not talking about local control and local discretion of school boards and public schools simply for the sake of discretion, but we're talking about the kind of discretion and freedom that's necessary to devise local policies that are narrowly tailored and that meet the needs of the communities. One of the things I think that is significant or illustrates this is, for instance, in the Louisville situation, where there was at least one formal survey done of the constituency, and then I think they held something like 5 public hearings on the whole question of their policy. You'll be interested to know also that in Louisville, as is the case really across the board with these diversity policies that school districts eventually develop, the constituency, parents and students, tend to be happy with the policies that are developed, primarily because they have that input. I think the figures that I've seen are that in Louisville, 77% of the white parents were happy, and about 89% of the African Americans were happy with the policy. So lots of sort of grassroots support, lots of support from the base, support that I think matters to the court. We know, for instance, that Judge Kaczynski points out in the Ninth Circuit situation, he points out in the Seattle case that there was this groundswell of support and that judges shouldn't really replace, even at his level, shouldn't replace the discretion or the insight that school boards have developed connecting with their school districts at the lower levels. But from the policy perspective, the National School Board Association and school districts are really interested in addressing the question of racial isolation and what diversity means in preparing students to be productive citizens. We know, for instance, in the Seattle case that racial isolation was one of the concerns of the school district. And that's one of the issues that they sought to remedy, with the student populations being almost equally divided or fairly divided between north and south in that school district. But we know also that other countries are making advances in math. India and China, both very compelling and rising economies, exporting many of their students. So there's no question that in order for an education to be significant for students today, it's not simply how they achieve on standardized tests. It has to be about the civics portion. It has to be about the interpersonal communications. It has to be about the connection with other people who have other experiences. That's the primary interest of the school districts in pursuing diversity policies.
Thanks, Francisco. We'll now turn for, I think, a different perspective from Terrence Pell, who, I can't promise that, but I'm guessing, who is president of the Center for Individual Rights. And the Center for Individual Rights is the organization that brought the Gratz and Grutter cases against the University of Michigan 5 or 6 years ago. They've also filed an amicus brief in support of the plaintiffs in the Louisville and Seattle cases. In the 1980s, Mr. Pell was a Deputy Assistant Secretary for Civil Rights in the U.S. Department of Education and has held a number of other positions, including Chief of Staff at the Office of National Drug Control Policy, and has also been in private practice, I believe. So take it away.
Thank you. Well, I think one of the problems with Supreme Court jurisprudence, not just in this area but in a lot of areas, is that it rests on various abstractions that tend to suppress real-world facts and crucial facts. And so what I want to do in my very brief comments is mention two facts that I think are overlooked about the Seattle Racial Balancing Plan, and then offer one quick general observation about what the Supreme Court should do about this. First, as John Payton, I think, has explained, and I agree with him about this, the best justification for the Seattle plan is that it furthers cross-racial interaction among high school students. To use shorthand, this might be called the rubbing elbows rationale for race-conscious policies. And in the abstract, I agree with John that rubbing elbows can be a good thing and generally is a good thing. It promotes racial understanding, mutual respect, and it correspondingly reduces the chance that racial stereotyping can take hold. But I think in at least one respect, this is an artificial description of the racial reality in the Seattle school system. The main problem, I think, for racial understanding in Seattle is not that students don't have enough opportunities to rub elbows with each other. It's rather that the interaction has to be contrived by the state in a way that ends up reinforcing racial stereotypes and inevitably produces a certain amount of racial tension. I think the salient fact that defines racial relations in the Seattle School District is that the schools themselves have failed to provide a minimally adequate education for certain racial groups. Notably and most importantly, African American students. And I don't have to tell people in this room about this problem, but just to cite one statistic to sort of call this problem to mind, 66% of the 10th graders in the Seattle school system overall read at grade level, whereas only 35% of African American students do. So I don't think it does justice to the educational reality in Seattle to simply say that there are natural racial misunderstandings that can be corrected just by having students rub elbows with each other. The educational disparities that we're talking about here are huge. Whereas a majority of non-African American students can read at grade level, a majority of African American students cannot. This, I think, is the fact that makes racial understanding problematic in the Seattle school system. And I think it's intuitive that this kind of disparity gives rise to a number of pernicious racial stereotypes. So I think it's somewhat misleading for all of us and for the court to be talking about improving racial understanding in Seattle, all the while leaving off the table what has got to be the single biggest obstacle to racial understanding, cross-racial understanding and racial harmony in the schools of Seattle. And I think it's more than misleading or worse than misleading to suggest that the problem here is choices made by individual parents and individual students to attend one magnet school rather than another magnet school, or even to attend their neighborhood school. The real problem here aren't the individual choices of parents and students. It's, I think, more clearly identified as the systematic, pervasive, and overwhelming failure of the government to provide a minimally adequate education for its African American students. I think at best the Seattle Racial Balancing Plan is a distraction from the real problem in the Seattle schools. But I think at worst, and this is, I think, what we ought to be careful about, and what I hope the court will acknowledge, at worst, the Racial Balancing Plan makes it less likely the schools will seriously address the racial disparities in educational achievement. And that's because, in effect, the Seattle Racial Balancing Plan hides the problem of disparities in academic achievement by ensuring that each school has something approximating the racial mix of the district as a whole. That way, no single school has too great a percentage of either high or low achieving racial groups. And as a result, partly as a result, all of the schools tend to perform at the same average level, helping to mask what are real racial disparities in educational achievement in Seattle. The second fact that I think is overlooked that I want to call attention to is that the Seattle racial tiebreaker system tries to produce racially diverse schools solely through the means of, solely by preventing schools from becoming unacceptably white. And I think preventing schools that are too white is not quite the same thing as promoting diversity. And in fact, as the Seattle case illustrates, can actually undermine diversity. Essentially what the Seattle schools do is that in order to avoid schools that are too white, the Seattle schools plan lumps all non-white students together as a single group, ignoring the actual diversity among that group in favor of what I think is a condescending dichotomy between white and non-white students. In other words, the diversity that the Seattle plan furthers and around which it's built is not the actual real racial diversity of Seattle. It's rather a constructed, abstract, and I think suspect conception of diversity that focuses solely on the white, non-white balance in the schools. This conception, I think, treats as interchangeable and equivalent the different groups composing the non-white student population. It assumes that white students benefit from exposure to any minority student, regardless of race, and it assumes that minority students as a group benefit from exposure to white students more than, say, exposure to other non-white racial groups, other than their own. I think in addition to promoting an exaggerated distinction between white and non-white students, the Seattle plan produces schools that are less diverse than they might otherwise be. That's because the Seattle plan suppresses minority enrollment every time white enrollment starts to get above starts to drop below 25%. So just to take one example, in 2001, the Franklin High School in Seattle had a projected white enrollment of 19.8% without the use of any sort of race in the admission system. Well, this was deemed too low because it was below 25%. And so white students were given a priority admission over non-whites in order to bring the white percentage up to 25.1%. Well, in order to do this, Latino and Native American students at Franklin, who are already considerably less well represented than the white students, and hence more isolated than the white students, were actually decreased in number in order to make room for the additional white students. Just to sort of drive this point home, this sort of absurd consequence of the way the Seattle system divides students into white and non-white groups becomes apparent when you realize that under the Seattle plan, a school that's 20% white, 20% black, 20% Latino, and 20% Asian and 20% Native American is treated as racially imbalanced. But whereas a school that's 50% white and 50% Asian is treated as completely racially balanced in Seattle. So essentially what this system does is suppress real racial diversity in favor of sort of an abstract black-white diversity. Now I think the problem here, and what the court ought to focus on, is that the way in which the Seattle plan focuses on the white, non-white mix suggests that this plan is not primarily designed to further racial diversity, so much as it is to prevent schools that either look too white or look too minority. But this suggests that Seattle's intentions have a political component to them. They're as political, perhaps, as they are educational. And for that reason, I think the court ought to be skeptical of the reasons that Seattle gives for what it's doing. Let me just quickly close with a general observation here. I think it's too bad that the Seattle case, the case the court is going to decide, doesn't really raise the real issue that ought to concern the Seattle schools and ought to concern anybody who's interested in the Seattle schools, namely the poor job it is doing educating African American students. Instead, the Supreme Court is really going to have to decide a different question, that is, what to do, if anything, about the Seattle school system's kind of confused effort to apply a Band-Aid to that problem by shifting white students around so that they comprise at least 25% of every school. I don't think we have to ascribe evil intentions to Seattle school officials. I mean, I agree with what was said before, but I think we can all recognize that there's an inherent danger here in allowing schools like Seattle to mask deep disparities in educational achievement under the guise of promoting diversity. It's enough, I think, that it's very difficult to tell what Seattle's many motives might be and to separate those motives out in its efforts to shift students around in this manner. I think the Supreme Court made a mistake in offering the diversity rationale because it encourages schools to engage in all sorts of games, some of them better games than other games, but it makes it hard to tell what the games are. And the danger here, I think, is that the idea of diversity, as it was described in the Grutter decision, is so loosely connected to any particular end other than just the value of diversity itself that it makes it very difficult to tell in concrete cases what hidden racial agendas might be operating. So, you know, this problem of the sort of mixed motives and agendas kind of hiding behind the surface of things used to be treated by the Supreme Court as a very serious problem, and it was considered such a serious problem that the Supreme Court would strike down you know, non-essential racial classifications just on the general theory that if you didn't know what was going on in the background, it was best if the schools didn't engage in any sort of racial classification. Well, I think it's prudent for the court to again acknowledge that racial classifications, even well-intentioned racial classifications, have hidden costs, and that these costs may be visited most heavily on certain racial groups, and sometimes on those racial groups least able to afford these sorts of distractions from what the real educational mission and the real educational focus of the schools ought to be.
Thank you. Our next speaker is Tamika Brown-Nagin, who's a professor of law and history at the University of Virginia Law School. Tamika has written extensively on the civil rights movement, and in particular the relationship between the community base of the movement and its lawyers. In the Louisville and Seattle cases, Professor Brown-Nagin was the lead historian on the very interesting amicus brief of historians of the civil rights era. Tamika.
Thank you, Phil, and thank you to the Center for inviting me to be here to add an historical perspective to this discussion. So, as a legal historian, I must insist that these cases most certainly are not about diversity for diversity's sake, nor are they cases about diversity unmoored from questions of discrimination, as commentators who see these policies as nothing more than the flip side of Jim Crow insist, or even as the legal posture of these cases demands, as John Payton has explained. So what are these cases about? Well, as I see them, they involve two concepts. First, they're cases about history. They're a referendum on our nation's history of segregation and discrimination in education and their continuing effects. They also are cases about democracy. These cases bring to the fore the question of whether school districts really should have taken seriously the court's repeated endorsement of the concept of local control of education. So I want to spend my time elaborating on the connection between these two, history and democracy. On the history part, first of all, these cases, both of them, remind us that Brown versus Board of Education has a tortured history in our country. The histories of both Louisville and Seattle are marked by a pattern of racial discrimination and resistance to school equality, sometimes violent, from which no community in our country has escaped, whether or not segregation was mandated by law or by custom and practice. We tend to talk about de jure segregation as if that's all that matters, but of course segregation by custom and practice was just as effective and devastating for those who experienced it. In Louisville and Seattle, as in so many other regions of our country, it took federal court action or the threat of litigation to open up white schools to African Americans and other minorities. And in most cities, as in these two communities, the process of school desegregation did not really begin until the mid-1970s. So not 1954 as we turn to when we think about Brown versus Board of Education. It's the mid-1970s which we should focus on, because it's at that point that the court decided the Charlotte case, which was so important for dismantling segregation throughout the country. As I see it, the voluntary school desegregation programs that are now before the court are a positive outgrowth of this very difficult history. The policies indicate that Americans in Louisville and in Seattle and many other districts across the country have now internalized the normative ideals that animated Brown versus Board of Education. Citizens are now embracing what in the past they had spurned, which brings me to the connection with democracy. Since the era of massive and passive resistance to Brown, which, as I said, spanned through the 1970s, there's really been an amazing shift in public opinion. A shift from overwhelming acceptance of segregated schooling to overwhelming acceptance of the principle of integrated schooling. And that shift in public opinion is a product of the desegregation of schools and public accommodations that was accomplished by the Supreme Court and the U.S. Congress. As people have experienced integrated social spaces, they've come to accept integration as a social norm. So now over 90% of Americans support integration as a principle. In Louisville, an overwhelming number of parents, 80% in one of the studies that I have recently seen, support the policy that is at issue. Now, Seattle is a bit more complicated, as we all know. There are no public opinion surveys similar to the ones that we have for Louisville. And yet what we do know is that the Seattle School Board has continually consulted the public in formulating its policies, that it's held focus groups and other community forums at which people have been able to express, frankly, dissatisfaction with some of what the school board was doing. And so as a result, the school board has actually dialed back its policy to the very modest one that the court is reviewing now. I would suggest to you that that actually nicely illustrates the point that these policies represent democracy in action. They're democracy on the ground, and they really show what an important part school boards play in that process. School boards in both of these communities are providing access to higher quality schools to African Americans and other racial minority students who on average attend schools with fewer resources, with less credentialed and experienced teachers, with more impoverished and less academically prepared students than whites. They're doing so of their own accord rather than under the thumb of the federal courts. In my view, it would be ironic if the court would now quash the democratic consensus that exists in these communities in support of school desegregation. It would be ironic in part because those programs are consistent with the court's school desegregation precedents, at least from the 1990s. It's what the court has all but asked for when it has repeatedly endorsed local control of education, as it has dialed back mandatory school desegregation decrees. So I will conclude by saying that a decision by the court that would strike down politically accountable school boards' voluntary desegregation policies would undermine Brown, a decision that legal historians, that really political commentators across the political spectrum view as one of the court's most important legacies. It would really imply that when the court endorsed local control of education, that it endorsed it with the proviso that its local control provided that school districts don't take even modest steps to confront inequality, and that would be I would submit, a really astounding statement for the court to make. Thank you.
Thanks. We'll hear now from Douglas Harris, who's an assistant professor of education and economics at Florida State University. Dr. Harris' research on educational equity and accountability has been published in the American Journal of Education and presented at recent meetings of the Harvard Achievement Gap Initiative and the UNC Center for Civil Rights. Professor Douglas will discuss today his new research on minority student achievement and school segregation, which I hope you picked up a copy of, which was just published by the Center for American Progress.
Thank you. So I'm going to talk about the new analysis I've conducted on the effects of segregation using data from No Child Left Behind, just recently made available. And I'm going to talk a little bit about the implications of that for segregation and its effects. I think I'm also indirectly going to be challenging a lot of the assumptions that were made earlier by Terrence Pell about the independence of the performance, academic performance of students in Louisville and Seattle and other districts being independent of the level of segregation. So the evidence is going to suggest that these two things are closely related and that segregation can help address those differences in achievement. As was said, this report is just being released today. There are copies available. It's on the website for the Center for American Progress, and I want to thank them for funding and publishing the report. So the new analysis. As many of you know, No Child Left Behind requires that schools test students in grades 3 through 8 each year, and that these scores be reported by racial subgroups. Now, what I've done is to assemble these data for about 22,000 schools that enroll about 18 million students around the country. This is about 1 in every 4 schools in the country. And only for these schools is it possible to calculate learning gains for racial subgroups, and I'll explain the importance of that in a minute. But compared to previous studies on segregation, this is probably 6 or 7 times larger than any previous study on the subject because of the new requirements of No Child Left Behind and the increased testing. So the approach here is relatively simple. Actually, let me take a step back. The importance of the learning gains first. Most previous research of just about any kind on education, and especially the accountability systems, tend to look at achievement at a point in time. They look at the percent proficient, the average achievement, and so on, just at a single point in time. The problem with doing that is, from the perspective of understanding the role of schools, is that a lot of the differences in achievement between racial groups is due to factors outside of school. For instance, we know when students start kindergarten that African American students start off a half a standard deviation behind, which in statistical terms it's enormous, right? Very large. The achievement gap gets a little bit wider as students progress through school. And so there are both school factors and non-school factors, but if you only look at a particular point in time in school career, you're not really you're capturing just what the school is contributing or what segregation in particular is contributing, but you're capturing a whole range of factors. So the real innovation here is to be able to calculate learning gains for these racial subgroups from year to year in these 22,000 schools. So what are the results? So the basic question here is, do minority students learn more in majority white schools versus high minority schools? The answer is yes. For example, the average African American or Hispanic student in a high minority school falls behind by about 4 percentile points per year compared with other minority students in majority white schools. So they're learning less in the high minority schools. I also considered what these results might have for controlled choice and desegregation in particular. The numbers I mentioned just a minute ago are kind of looking at the extreme ends of what happens if you have a student in an extremely high majority white school versus something more modest. And realistically, the amount of desegregation you can accomplish with controlled choice is lower than that. So I conducted some simulations for using data for Seattle and Louisville in particular, and the results, again, the general conclusion here is the same, that these programs do seem to be raising achievement in those districts and in general across the country where desegregation is being accomplished. These results hold for different statistical methods. They are almost always statistically significant by the usual research standards. and they are consistent with previous research on the subject. So another thing I do in the report is to go back and review a lot of previous evidence on the desegregation experiments, for instance, that occurred during the 1960s and 1970s, where students were randomly assigned. And the random assignment allows you to, in some ways, get better estimates of the effects. I looked at more recent studies using somewhat similar methods, but extremely detailed student-level data that are just now becoming available in states like North Carolina and Texas. I also looked at studies of long-term effects on college-going and employment. The consistency of the evidence is really striking. No matter what kind of study, no matter what kind of outcome you look at, students seem to do better, minority students seem to do better in desegregated schools. Okay. Now let me say a few words about why that might be the case, because one of the first reactions I usually get when I cite this evidence is, well, why should the color of the skin of your classmates affect your learning? So there are a few reasons why you might expect this to be the case, and it's not race per se, but factors that are very closely intertwined with race that we're all aware of. There's a lot of evidence in education in general that the two most important resources in any school are its students and its teachers. So your classmates matter. So in this case, minority students tend to come from families with parents who have lower levels of education, lower levels of income, and so on. Now that affects each individual student. So being a student who comes from a family with a disadvantaged background obviously reduces their achievement. But being in a classroom with other students like that also has effects, and it affects your classmates as well. So the students and the classmates are one factor. The teachers are another factor. So high poverty schools, high minority schools tend to be difficult learning environments. And teachers, for a large number of reasons, are less willing and less well prepared to teach in them. Teachers say they're less prepared. They're not prepared to deal with those challenges. And so if you look at the number of teachers who apply to teach in high minority schools versus low minority schools, vastly different. So you might get 2 or 3 applications for a math position in a high minority urban school, whereas you might get 50 or 100 in a majority white school. So there are significant differences there. Now, a third factor compounding all this is the way school finance works. Right? So school finance in the U.S. still is based mainly on local property taxes. Minorities have less property wealth and therefore end up with less money going into their local schools. So this results in lower salaries, which compounds the issue with teachers, and it also results in fewer other educational resources such as textbooks and buildings and so on. Now I want to conclude by talking a little bit about how desegregation fits in with the current educational reform movement and No Child Left Behind. We actually find ourselves in kind of a rare situation here with desegregation improving achievement for disadvantaged students, doing so at a relatively low financial cost. It's a program where we have reasons to think it should matter for academic achievement. We have evidence to back it up, and with this new report, I think even more evidence to back that up. If this were a new curriculum or a new kind of teacher preparation or a new management technique, everybody would be saying, let's do this. This is a dream come true if we could do all these things and raise achievement at little financial cost. But because of the racial aspect of this policy, instead of being a dream come true, it ends up being a dream deferred. There's one other similarity, actually 2 other similarities between No Child Left Behind and desegregation that I want to point out. One is that all of the benefits of desegregation I just mentioned are entirely consistent with the goals of No Child Left Behind, right? The purpose is to raise achievement and to do so efficiently. And that's the general direction of the current educational reform movement, and desegregation seems to accomplish that. And I also point out that so these are not just social benefits. So a lot of the panelists talked about the social benefits of desegregation, which are obviously important. But this suggests that you get not only social benefits, but academic benefits from this as well. So these are not conflicting policies. It's not like we had to shift away from some bygone era of desegregation to something more modern and to focus more on academic achievement. The goals of these 2 things are closely intertwined. Increasing social benefits and educational benefits are closely related. One final similarity is that these 2 policies, NCLB and desegregation, are both race conscious. Now, this is obviously true with regard to desegregation, where you're considering race in the assignment of students to schools, but it's also true of No Child Left Behind. Because remember, with the analysis I did, I couldn't have done it if the scores were not broken down by racial subgroups, and if schools were not evaluated on the basis of the scores of students in different racial groups. So it seems to me it stands to reason that if we're going to use, if we're going to consider race in evaluating schools, and we're going to require that we should at least allow the districts to consider race through such policies as desegregation, where there's, especially in this case, where there's a lot of evidence that those programs have educational benefits and achieve the same goals that accountability is trying to achieve.
Thank you. Before we move to questions, I don't want to have a rematch of the University of Michigan cases here, but I saw John scribbling some notes when Terry was talking. Do you want to respond briefly before we go to questions?
Just really briefly, I want to pull apart two things that a number of us have, I think, lumped together. And the two things are how are schools doing in their educational mission, the achievement gap, and the benefits of having a diverse classroom, because I think those are very different things. Having a diverse classroom has educational benefits, but it's not an educational panacea, and it does not, I don't think, even comprise the major thing that has to happen to close the achievement gap. Those are separate things. We have to deal with the case we have before us, and the case we have before us is whether or not a school district can use race in making school assignments in order to have integrated schools or diverse schools. I almost got the impression from what Terry said that if there were no achievement gap, he would not be taking issue with what's going on in these two school districts, and I know that's not right. Okay? So I want to separate those issues, and I think I'd separate them by saying, assume there is no achievement gap in these schools. Could the school nevertheless take race into account in order to have the benefits of either an integrated or a diverse classroom? And I also heard Terry say he agrees that those benefits are there. He just thinks that the argument, smoke screen and all that, take the achievement gap out of this. These cases are the cases we have before us. They don't raise that issue. I would be absolutely the first person in line to say we've got to fix our schools and deal with the achievement gap, but that's another set of cases.
Well, that relates to something I was going to ask Terry. The point you made about the failure to provide a minimally adequate education for African American students in Seattle, this is very close to what John's saying. What really concerns me about these cases being argued Monday is these principles being brought in from the affirmative action cases and applied in this context. I don't really see where it ends. And I don't really understand, if there were a targeted program to raise the achievement of African American students, as No Child Left Behind seems to demand, why wouldn't that be racially suspect in the next case coming down the pike under these same principles? But if you want to respond to John or to me.
Well, my quick response to John is that if there was no achievement gap, I don't think people would care about these attendance patterns. I mean, the reason why we worry about these attendance patterns is because a school that is predominantly minority performs at a much lower level than a school that is predominantly white, and that's a problem. It's a problem on a lot of levels. If there was no achievement gap, we wouldn't really care if there was, for example, an all-black school. It wouldn't have the significance that it does now. And furthermore, I think if there was no achievement gap, it's much more likely that schools would be racially integrated just as a function of the choices parents and children make to attend schools with different, educational programs or different magnet programs or different concentrations or emphases. I mean, one interesting fact about the Seattle School District is that schools that are undersubscribed, schools that are unpopular, schools that nobody wants to send their kids to, in a matter of 3 years' time, all of a sudden become oversubscribed, where everybody's trying to go, send their kids to those schools. Well, what's the reason for that? It's not accident. It's that the school system puts in some new program that everybody really likes, and they all want to send their kids to that school. So when you have a system of free choice where anybody can go to any school, and where the school system is deliberately trying to make different schools more popular than they might otherwise be, attendance patterns are quite variable. So if you combined John's assumption that there is no achievement gap with a system built entirely on free choice, I don't think you would have racially identifiable schools, and even if you did, nobody would be particularly troubled about them because they would know that in 3 years' time, the attendance pattern is going to be different anyway.
Questions from the floor? Richard? Okay, if you wouldn't mind stating your name and affiliation, if any, for the record, that'd be great.
Richard Collenberg with the Century Foundation. I agree with most of the panelists here who said that it is important to have racial diversity in the schools in order to promote tolerance and social cohesion. But I wanted to ask you, Doug, about the academic achievement side of this, because it seems to me that the logic of your remarks is that if the reason that black students gain in white schools is that they are exposed to middle-class classmates, then isn't the logic of that income desegregation the way they are doing it in Raleigh, North Carolina, and some other places?
Oh, yes and no. So up to the point where you finish your remarks, I think, yes, that's true, that the underlying basis for this is poverty, not race per se. And because these two things are so closely intertwined, that the benefits that you're getting as a result of desegregation by race are really coming from the resulting desegregation by poverty. But there's one reason where I might disagree with the idea of the income-based approach, which is that the evidence on the long-term benefits, and in fact the whole theory of the longer-term benefits, is somewhat different than the benefits for achievement. So the benefits of achievement I talked about in terms of classmates and teachers, and there are reasons to think that this contact theory is what it's called, I think sociologists call it, where the rubbing elbows, I think that was talked about earlier, that may or may not have anything to do with affecting achievement, may be more important for these longer-term benefits because students become more comfortable, minorities become more comfortable interacting with whites who, if they were to go to college, that's who they would be interacting more with in the workplace likewise. So I think race itself becomes more important when you look at the long-term benefits because of the rubbing elbows kind of idea.
Can I just, I don't want the discussion to go a little bit off track here. I think that we know a lot about race in this country because of our history. And I think one of the things we know is that race and stereotypes and racism don't follow from logical deductions from what you see happening around you. Racism has its own core in it. And it's not, gee, I looked at that school over there and they weren't doing well, and so I've concluded that the students in that school aren't doing well and they all happen to be black. Some of you in this room will remember not that many years ago when, in the context of professional football, there was an argument that black people wouldn't be good, get ready for this, wouldn't be good offensive linemen because offensive linemen really are the smartest people on the field. That black people wouldn't be good quarterbacks because it takes a lot of intelligence to be a quarterback. That they couldn't be good defensive players because you got to be able to take those signals and signs, and you can go on down the line. It went all the way across all 11 players on both sides of the field. Black people just couldn't do it. And that was based on nothing but racism. Okay? Every one of those is now gone. Okay? It's just gone. And as soon as it's gone, it's just gone. But what was influencing that was what our collective history has done with the concept of race. It is poisonous. And I think we have to figure out how we deal with that poison. It's not just, gee, it's that black people are poor. and we really have to deal with the poor people, and why don't we just look to deal with, SES? That's not it. Race has its independent quality, and it's an independent poison. And I do think we have to be very careful how we use it. I'm not for just letting anybody use it in any way they want because they say good things. We have to be very careful about it. But race has its independent poisonous quality, and it's not just about, people, make logical deductions from what they see around them. It's in our culture, it's in our families, it's in jokes, it's in movies, it's in cultural history, it's in our history, and we have to do these things in order to excise it.
Oh, in the back there, black suit.
Blue.
Blue, sorry.
Ken Jost with Congressional Quarterly. I guess the question would best be addressed to Mr. Pell and Mr. Payton. Professor Liu's article on the line somewhere says, in fact, that the correct body of law to look at, the correct body of Supreme Court law to look at is the racial redistricting cases, and the correct answer to the question is that race can be used in school assignments as long as it's not the predominant factor in assignments. And I wonder whether Mr. Payton, Mr. Pell think that is or is not the correct answer, and if so, how each of them would fare under such a test.
I've read Goodman's piece. I don't think I have settled on a really fully thought-out concept. It's intriguing, but, I think we have sufficient bodies of law in the desegregation cases and in the Michigan cases to actually pretty easily sort this out, rather than going into an area of the law that is actually for you not lawyers, it's insulated separate body of law, how you deal with redistricting. And it's insulated and separate because there are all sorts of very peculiar, unique issues that come up in the political context of drawing a political boundary when politics can take account of almost anything when you vote for people to do things. So I don't think we have to go over there, but I think this case comes out fine under the existing bodies of law. I'm not sure Goodwin's analysis yields a different result, though. It's just an interesting academic analysis. Sorry about that, Goodwin.
I would just say quickly that I have not read the article either, but the general idea that so long as race isn't a major factor, as long as it's just kind of one of many factors, is, I think, a potentially misleading way of looking at this, because as soon as you say that, what you're saying is we're not going to look very closely at what the state's doing here, as long as they can point to some good reason, as long as there are some other legitimate or, factors that go into the decision, then it's okay. And I think that obscures a lot of things that may be going on in these particular cases that, should make us uncomfortable. So I'm not comfortable just saying, and I don't think the court should be comfortable saying, well, so long as it's just one of many factors. I think that opens us up to too many sort of forms of political manipulation. I mean, I'll just leave it at that.
If I could sort of add my piece, I think the comments were made about that suggest that the school boards all across the country are engaging or have some sort of nefarious intent when they're developing their diversity policies. I think a close examination of what happens in Seattle, as was pointed out by the professor, and a close examination of Louisville really belies that point. I mean, there's nothing nefarious going on there. There's not a proxy for some other intent, whether it's some reverse Jim Crow law or reverse discrimination piece. Nothing of that kind is really what's happening. Quite to the contrary, what's happening is that school districts are looking very closely at their communities. The Supreme Court has already recognized that it makes sense to defer to local school boards because they're at the grassroots level. They're connected to their communities. Parents opine about what happens to their kids and where they go to school. So I think to suggest that there's some other reason behind it, and I'm not quite sure what that reason would be, you haven't quite stated it. I'd be fascinated to hear it. But I think that what we know about what's happening in Louisville and what happened in Seattle belies that.
Yeah, I don't think there's a nefarious motive. I think it's just hard to know what the motives are. I think school boards are kind of funny entities. They have a lot of different constituencies that they have to respond to in a sort of political way to keep everybody happy. And on top of that, they have the federal No Child Left Behind Act, which attaches real penalties to school districts anytime they have a single school that performs at a below average level. So regardless of what a school's intentions are, it faces pressures to make school disparities go away, even if they don't make racial disparities go away. And so what happens is that racial disparities are converted or hidden in an effort to make all the schools align and converge on a certain average level of performance. That's not saying the school boards are nefarious. It just says the school boards are behaving like you would expect school boards to behave, and we shouldn't necessarily go along with it.
I have a question from the table before I go back to the floor.
Terrence, I just wanted to follow up on the point you've made a couple of times about how they're trying to hide the achievement gap differences. Given No Child Left Behind, how could they possibly do that?
Well, the way No Child Left Behind works is that if you have a school that underperforms other schools, you have to engage in certain remedial efforts and provide extra tutoring and various other things. If all of your schools are performing at the same level, it doesn't trigger these No Child Left Behind penalties. I do agree with you that you still have to report performance broken down by race. But even having done that, you don't trigger all these remedial efforts, which seem to be focused on school underperformance, not individual underperformance or even racial underperformance.
But the mechanisms don't trigger based if performance is even across the schools. It triggers if somebody's not proficient or they're not making adequate yearly progress. So
no, if a school is not proficient or a school is not making adequate yearly progress.
Well, but by that logic, it's in the school board's best interest to have racially homogeneous schools so that particular schools are not penalized under No Child Left Behind. And in fact, that has been the critique of No Child Left Behind, that it actually encourages school districts to not do anything about racial imbalances. So I really don't understand the point, or it doesn't seem to be very persuasive.
Over in the white shirt. My color's wrong, but that's, it's white. Okay, good.
I had two questions, kind of going off what you were saying. Integrated schools have more opportunities to fail than segregated schools because you have more, when you have more racial subgroups, you have more opportunities for racial subgroups to not perform. So it would be, like you said, in their interest to maintain homogeneous schools rather than integrate them to hide that. But the question I had was about if there's any potential for cross-district integration. I used to teach in Philly, and we have, what we're seeing in large urban school districts now is that they're so overwhelmingly, predominantly children of color that integration is not even really going to be an option within that district. And because of the way resources are distributed, if we want our kids in the cities to have access to more resources, what are the options for sort of doing crossing district lines to integrate schools? So,
I think that's a great question because these are two large, one urban and one metropolitan-wide district that have the luxury of having an internal diversity within the districts that they can work with. And, many parts of the country have a really balkanized system of education where you have a central city, completely segregated high-poverty school district with predominantly white middle-class districts on the in the suburban ring. And does anybody have a thought on that? I mean, is there anything in these decisions that can reach that? Is there anything Congress can do?
Yeah, these decisions aren't going to say anything about Milliken versus Bradley. It's not going to do that. That's the decision that says you can't cross from inner city to suburban school districts, even to remedy a de jure violation. You just can't do it. These are unusual school districts. Louisville, I'd say, is quite unusual. Because it has lived a horribly segregated life as a segregated school system then had, years under a court order to integrate, and has concluded that those, what integration taught it is that there is a value they want to continue going forward, and they want to do it so that, in fact, they don't become a balkanized district and can maintain some of this. They're 35%, 65%. That's itself unusual. If there is, a strange glint of hope in all of this for those inner cities that have become almost homogenous, it is that gentrification, which gets a very bad rap from an awful cross-section of folks, actually creates opportunities in inner cities, and now's the time to take advantage of it by fixing the schools in a way that, in fact, will lure more people back into the inner cities. And gentrification is happening across the country. It does have a bad rap, but it's happening. But that's what is the engine for trying to fix some of these problems in a way that I believe could make us healthier.
In the green shirt over there.
Two questions, hopefully one very short. Harry Kruglich, Senate Democratic staffer. For Mr. Pell, I had a couple of points you made that I liked. One, that there is a benefit to diversity, and two, that a half-white, half-Asian school is not necessarily reflecting the diversity of the city. And so wouldn't that suggest that maybe we need a more integrative system, although that would be almost certainly struck down by the court? But I mean, is that where you were going? Because you said that we need, that the diversity of the city is not reflected. That would suggest stronger measures, no?
Well, I think that if the court goes along with this at all, it ought to insist on those stronger measures, because at least they make clear that that's what the school is seriously trying to do, rather than leaving it open to people like me and parents and students to think that there are other games being played. So I agree. I think in the area of race, for precisely the reasons that John mentioned, it's very important that the government be above board about this. If it says that its goal, is racial diversity, and that this has, sort of has the rubbing elbows benefit, then it ought to be serious about that and do it in an above board way, such that everybody can see, okay, that's what's going on here. This program is designed to achieve that objective, and it's not being used to further and promote some other agenda that we're not particularly comfortable with.
And wouldn't the schools do that but for the fact that the courts have already struck down quotas? Open question.
Well, I think as John indicated, we're dealing with a new body of law that's developing here. It's based on the diversity rationale in Grutter. There's all different kinds of ways this could go. I remember at the beginning of the Michigan litigation, John said, look, well, I'm paraphrasing, but what we need here is a clear commitment one way or the other. If we're going to do this, let's embrace the diversity rationale and do it, above board and across the board. Let's stop injecting these kinds of legal tests that don't, that sort of frustrate the true objectives of a diversity program. We, on the other hand, were saying the way diversity is used by the University of Michigan is so compromised, let's get rid of it altogether. I think John and I, believe me, I'm really paraphrasing here, but I think John and I would agree, let's do it one way or the other way, but let's stop playing games in the middle.
My other question to John, and certainly feel free to respond to that, but do you think the states' rights argument will have any resonance with the court personnel who might be less inclined to support our position on this issue in these cases? And also, feel free to address Terrence's points. Thank you.
I think the states' rights argument is limited to the following, that if achieving integrated K-12 schools or achieving educational diversity in K-12 schools is a compelling interest, then the school districts are entitled to some leeway about how they go about doing it. But I think they're entitled to very little leeway in defining the first part of that. So it's not, gee, you can do anything you want. And, if you want to get a hint of what the past looked like, every southern state filed a joint amicus brief in Sweat versus Painter. It's the case that is the run-up case to Brown. And it was about the University of Texas Law School, which was for white students only. And their amicus brief essentially said, we're the southern states. We know Negroes, you don't. We deal with them for hundreds of years, you haven't. We have to segregate them, and we're going to tell you why. And here's what we have to do, and give us complete unfettered discretion to deal with the Negroes. It's in the best interest of both races. Okay? No one has made that argument since Sweat versus Painter.
May I jump in for just a second on the question about the diversity rationale being subject to being manipulated, and there's a lot of concern about that. I want to remind us that the reason that we are here is because the school desegregation cases, that project of trying to come to terms with Brown within the context of discussions of discrimination and history, was essentially closed down. So we're essentially trying to implement Brown through other means using this term of diversity, which I will agree can be vague, but in this instance, I think what I've tried to say here is true. We really are dealing with parents of their own volition and school boards wanting to fulfill the promise of Brown. I don't think that there is any controversy or any that's out there. That's what we're trying to do. So to say that it's just unclear what the motives are, I think is a little disingenuous.
Okay, we have time for one or two more questions. The beige jacket.
Thank you. My name is Shelley Weinstein. I have long since left the field of school finance. I'm deeply sorry about that, but I'm in global education. I head up a not-for-profit organization. But I would just like to make two comments about the issue that if we had no achievement gap, that there would be no problem, and that belies the fact that you are suggesting that American society is ready to move back to separate but equal because of where we were. And do not believe you can separate the two. Mr. Payton, I think your rebuttal to that issue was absolutely excellent, and I can understand for the court cases on December the 4th, you don't want to get it muddied up with school finance. But I remind you that school finance came after the Brown decision, that the rich schools, poor schools by Arthur Wise, that the whole issue of what each state did and what the southern states did to show that they didn't have to meet the desegregation by showing that they would fund equally and still not do it. So you cannot separate socially and legislatively the school finance issues from the equal but separate issues. They are very much a part. It is why society is and why Tamika talks about the whole social and historical reasons for these problems. But I really don't believe that legislatively and society, school boards, or parents should be assumed that they would be willing to, if there were no achievement gap, that we would leave out the issue of racial issues at all. That is not where my community, and I'm a grandmother, none that I know of. And it is none in the global education issues that I deal with in the Mideastern and North African countries. It more and more is perking up, whether it's girls and women, minorities, or certainly the religious issues about Islamic and Christian, so that these are things that if, in fact, we do not include them, you may not want to include them in a court case, and I can understand that, but they are a part of education policy.
Yeah, I completely agree with your point.
I think the evidence of separate, we are very much moving back toward a separate but equal, or a separate and unequal system, And I think the evidence of separate and equal schools is very rare. That's largely because the hyper-segregated schools are also high-poverty schools, and there are rare examples, usually resulting from extraordinary leadership combined with massive infusion of money and restructuring of schools. But by and large, it's rare that a separate, a racially and economically separate school is equal in this country. You can probably count the examples on one or two hands.
I guess I should say what I took to be the main point, which is that if we were here and the topic was educational policy K-12, what is to be done, we would make no artificial distinctions between any of these things we've been talking about. We have the case that's before us, and it's about a little sliver of that problem. But if we were here just to talk about educational policy, all the things that we've talked about go together, and you got to solve them together, or you don't get the whole thing solved. But we have a slightly different kickoff point here, which is two cases before us, and we're stuck with those.
Well, and just as the case on Monday is not about education policy generally, it's also not about the use of race generally in social programs. There's so many ironies surrounding this case. One of them, yesterday I was at the State Department at a meeting where the various officials were talking about their upcoming report on U.S. compliance with the Convention on the Elimination of All Forms of Racial Discrimination, a treaty we signed and ratified which commits us to monitoring racial segregation, racial disparities, racial discrimination, and taking affirmative steps to remedy them. That they're over there, and the Justice Department's arguing kind of the opposite thing on Monday. So, but again, that's not before the court on Monday. This realm of race-conscious programs generally. Time for one more question.
Hi, I'm Sarah Portel, Center for American Progress. I was wondering if anyone, particularly Mr. Payton and Mr. Powell and others, wanted to do any psychic activities and talk about your thoughts about the court's interest in taking these cases, the interest of any particular judges, why logically this might have made sense for them to take it now, and any, not necessarily guesses on the outcome, but guesses about the thinking of the court at the moment.
Not a chance.
Anyone else?
No.
Both
I concur. Well, thank you all very much for coming, and thank you to ACS and the Center for American Progress.